is a part-heard appeal in the matter of Titanium Capital Investments Limited and another, and Hughes and others.
Mr. Bayer, you're on your feet. Does that mean nothing further from Ms. Hilliard? Oh, I see there's a note here.
Yes, we prepared a note overnight of the references that we found to business connection.
Yes, thank you very much. Yes.
What I want to do is look at the facts. I think it was Lord Gough in the Spiliada case who said that the law is an educated reflex to facts. Now, this isn't an appeal on the facts, but nonetheless, that the propositions of law that are put forward obviously need to be considered in the context of the facts. And you've heard quite a lot about the facts already from Ms. Hilliard, not all of which is common ground, I'm afraid. So I'm going to summarise the facts under 7 headings. I'll just tell you what the headings are. I'm going to talk about, firstly, the origins and the scope of the partnership. And I should say my focus throughout is going to be on the findings in the judgment, but it's not a criticism, certainly on my part, of the learned judge, that his findings are distributed across the judgment in what is quite a densely woven artifact. And so I'm hoping that it will be of some help if I pull together those findings in the way in which we say they can logically be structured for the purposes of the issues that you're faced with. So heading 1 is the origins and scope of the business. Heading 2 is the ACON relationship. Mr. Brand from my instructing solicitors has counted that there were 1,031 references to ACON during the course of this 15-day trial. You can do that because obviously there's an index at the end of each day's transcript, but there was quite a lot of attention paid to ACON, as you can see. The third heading is the main focus of the business, which was, as you I'm sure appreciate, which was governmental sales. And in that context, I'm also going to be looking at the detailed findings that the judge made about the origins of the so-called Danish deal. So that's the third heading. The fourth heading is Newfoundland. Not the main focus of the business, but obviously a facet. The fifth heading is the judge's findings in relation to what might be called misconduct on both sides. The sixth heading is dissolution, what the judge found in relation to that. And the seventh heading is post-dissolution. So can I ask my lords and my ladies to take up the judgment, please? Page 92, paragraph 34. Having recited the personal backgrounds of the two men, the judge found that in 2020, Mr. Manduka and Mr. Hughes started investigating the possibility of starting a business together that might thrive in the conditions of the COVID emergency. And I mean, we were all there, but those two short words, the COVID emergency, are very important in assessing the context. And I needn't elaborate on that, although I may take you later to some judicial findings, as it were, that just helpfully bring together what we all recall. But plainly, there was an emergency, which, as we all remember, started with the emergence of this hitherto unknown virus at the very end of 2019. It came to public attention in January 2020, etc., and had a disruption greater than anything since the Second World War, as has often been said. Paragraph 35. In the third quarter, Mr. Manduka started to think about business opportunities involving COVID testing. And as the judge records, at this time, the standard approach to COVID testing in the UK, and the court may recall this, was what was called a PCR test. and the PCR test, you had to give a sample which would then be sent off to a lab, and it would come back, or the results would come back, but it took 3 days to get the result, to find out whether or not you had COVID. And of course, that was, as we all know, a completely ineffectual way of dealing with the conditions of the pandemic, because in the intervening 72 hours, given the extreme transmissibility of this disease, you could have become infected, or you could have developed symptoms which had been still just about latent at the time of giving the test. So the PCR test, which was pretty widespread at that stage, it was the stage of eating out to help out, etc., if you recall, was actually pretty useless. And so Mr. Manduka formed the view that something better was needed because of this factor of delay. And something better was needed, and of course therein lay an opportunity, a business opportunity. And that was discussed within the family in September, or rather before September, I should say. In paragraph 37, Mr. Manduka came to believe that there was real potential in a business that sold lateral flow tests. Now, just pausing there, what is a lateral flow test? Again, I mean, we all know, if we didn't before, what they're like, because we've used it, but it is a mechanism that allows you to add a sample of something onto a pre-existing test bed which contains something that's already been put on it. And if there is a reaction, then that's visible. So one example in a different context would be a pregnancy test. These tests were antigen tests, so they tested for the antigen. The antigen is part of the virus, it's an extract of the protein spike in the virus. And so what you do, as I'm sure the court knows, is a sample is taken from the nose or the throat, from the tissues there. You get some mucus or some saliva. You then mix it up with a reagent and then add it to the litmus paper. And in the reagent is something which, if you are positive, if you have the antigen, will react with the antigen. What is that thing? Well, it's an antibody. So, because that then gives you a reaction. And so Mr. Manduka came to believe that there was potential in a business that sold these lateral flow tests, and he decided to approach Mr. Hughes, and there was a dinner on the 19th of September with their respective other halves. And the judge explains in paragraph 38 that the business in the third line that involved the purchase and sale of LFTs would need funding, it would need working capital, and it would also need administrative and logistical support. So that was why it was important, or part of the reason why it was important to bring Mr. Hughes in. And we can just go forward to paragraph 40, although we're going to go back to 39, but just to see a little bit more about that on page, the top of 94. When forming the partnership, both Mr. Manduka and Mr. Hughes considered that a prize to aspire to was the award of a contract by the UK government for the sale of LFTs. Any such contract had the potential to be highly lucrative because of the sale of a large number of tests. They set their eyes on that prize. And they considered from experience born out of the unsuccessful venture for PPE, protective equipment, earlier in the year, that they would be able to obtain a UK government contract only if they could establish that their business had real substance. And it couldn't just be a purely private partnership, an 1890 Act partnership. They had to be allied in some sense with HGL Hughes Group Limited, which was Mr. Hughes' established construction company, so nothing whatever to do with medical supplies, but it basically had a healthy balance sheet, as the judge recalls. And then one can see paragraph 39 as was common ground by the time of the trial, although it hadn't always been common ground, but by around October 2020, Mr. Hughes and Mr. Manduka had agreed to enter into the partnership, and as the judge finds, here are the aspects of it. And for relevant purposes, you know, little 2 it was to operate under the trading name of Hughes Healthcare. Its business was to be focused on the sale of LFTs. One notes the way in which that is expressed. And then it's a partnership at will, level 3, 50-50, and then point 5 is the point I just made about working funding and administrative support, and then other people, so that Mr. Manduka's son and Mrs. Manduka and LB at the time, now Mrs. Hughes, Lynn Blythe, then would work on the business, they wouldn't be partners, etc. Can I go forward just to a little non-chronologically, but to draw your attention to two matters which bear on the scope of the partnership, and this is goes for your notes at ground 1D, which obviously I'll address in due course, but I'm giving you the flag. So if you could go please to page 117. You'll see at the top of the page that the judge has the heading, the SHA, the Shareholders Agreement. And this is the agreement in the event it wasn't performed, but it was an agreement that existed, and the judge rejected various defences that were advanced in that regard by the defendants, by Mr. Hughes. He's explaining the genesis of this agreement, which was a disagreement, a row as he calls it, in February 2021, which meant that the partners realised it would be a good idea to formalise their relationship in writing. And the first step in that, which we'll look at in a couple of minutes, was a draft partnership agreement from Mr. Manduka's pen sent to Mr. Hughes. But Mr. Hughes took legal advice. He then approached Gardner Leader, I should say, at that stage acting for the partnership. And they produced the SHA, which was executed, as he finds in 160, on the 27th of April. And it didn't result in a dissolution of the partnership, but had it been performed, it would have superseded it. And as the judge records at 161, the parties are Mr. Hughes and then Titanium, and then two newcos, Hughes Biotech and Hughes Healthcare Labs Limited, HHLL, not to be confused with Hughes Healthcare Limited, HHL. And at 163, in the second half of that paragraph, the judge finds and accepts Mr. Manduka's evidence that HHLL, the newco, was intended to be a corporate vehicle through which the existing business of the partnership, note that phrase, consisting of the sale of LFTs manufactured by Acorn, again note that phrase, was to be conducted in the future. And as he says, that's consistent with the terms of the SHA. And then over the page at 166, clause 2.1 of the SHA described the business of both HBL and HHLL, and the judge summarises what the agreement says, but perhaps we can just go to it, see it as it was executed. It's in it's in the agreed supplementary bundle, and it's tab 16, page 74. So 74 of the agreed supplementary. And if you go to page 80, I should say, we start at 77 in the definitions clause, where you can see that business has the meaning given in clause 2.1. And then clause 2.1 is at page 80. And the business of each of the companies is as follows. And then company 1 is Hughes Biotech, the new company 2 is HHLL. to develop, research and manufacture lateral flow devices subject to variation from time to time. For Company 2, to distribute, develop, distribution, buy and sell lateral flow devices. So although the syntax isn't perfect, that phrase develop, distribution, maybe missing a word or two.
You're going to have to. I'm sorry.
Is it bothering you?
I've certainly got. You can't do anything about the helicopter.
No, well then it's perhaps I could.
I think you're just going to need to speak up a little
If I just speak, of course. I'm so sorry. It was my request to open the window because
No, the window's great, but
yes.
You're just going to need to speak up because
I can't compete with the RAF, my lord. No. I'll keep it up and please remind me if my voice falls a little bit. I was simply making the point that although the syntax has gone slightly awry, there may be a word or two missing in clause 2.1b because it's got this phrase develop distribution. So maybe that's develop distribution of or develop or distribute. It doesn't really matter because the key point obviously is that it's just lateral flow devices that are referred to generically. And the judge found at paragraph 163 that the definition in the SHA, as he put it, was that for a corporate vehicle through which the existing business of the partnership consisting of the sale of LFTs managed by it was to be conducted in the future. So in other words, putting it slightly more elegantly, the SHA reflected the existing understanding as to the scope of the partnership. And just to make the point that you will have seen in our skeleton argument, but the reason I'm drawing your attention to this is because we say this, among other things, shows that there was simply no question of the scope of the business being limited to the sale of branded tests, that's to say, branded with the Hughes healthcare brand. That's what I mean by branded. And since I'm on this point, can I just take you to a couple of other references? First of all, the Mr. Manduka's draft partnership agreement that wasn't taken up, but obviously is evidence of what at least he understood to be the scope, and it's perfectly consistent. That's at page 69. It's the previous tab of this bundle, tab 15. And you'll see under the heading Functions of the Partnership in the middle page that the partners have formed the partnership for the purpose of distributing and manufacturing lateral flow device test products. So again, a generic description.
It wasn't in dispute by the date of the trial that the partnership was between the two men, was it? It was a different part.
No, it wasn't in dispute. So this was intending to shift the business, and indeed something in a slightly different way happened under the SHA because the owner on Mr. Manduka's side was to be titanium, yes. So that was it, yes. This was the foundation that was set up in honour of Mr. Manduka's late daughter, who tragically died in 2016. Now, a couple of other bits of evidence, or rather materials, sorry. The judge, just going back to the judgment at page 97, still talking about the scope and looking at what information you have in that regard, the judge at page 97, paragraph 56, said this: Acon had its own branding, and the Acon brand was called Flowflex, that it used to sell its LFTs, and he defined that as unbranded, not because it had no brand, but because it didn't bear the brand of the partnership. However, Acon was also prepared to supply tests to the partnership that bore the partnership's Hughes Healthcare branding on its packaging and other materials, and the judge called that branded tests, and I'll use the same shorthand. Since the partnership was interested in promoting its own brand, its orders with Acon tended to be, and obviously I emphasise that verb, tended to be for branded tests. Because if that tendency is not the same as something which is a necessity or an absolute proposition. So if you find that something tends to be X rather than Y, you're implicitly finding that there is some of Y, even though it's predominantly X. And that's what this finding by the judge means. So the brand, Hughes Healthcare, the judge considered on the previous page, paragraph 52, when he said, having dismissed in the previous paragraphs an argument from the defence side, from Mr. Hughes's side, that the partnership was trading under some kind of licence from Mr. Hughes's company, HGL, the construction company. The judge dismissed that in paragraph 51, having found that Hughes, in 51.2, Hughes Group Limited could not have claimed any goodwill in the name Hughes Healthcare. That's the second sentence of 51(2). And so he finds, and it's not challenged on appeal, the right to trade under the partnership's chosen name of Hughes Healthcare was an asset of the partnership rather than of HGL. And by way of further corollary, when the partnership's successful trading caused some goodwill to attach to the trading name Hughes Healthcare, that goodwill was an asset of the partnership rather than of HGL. And we'll see when we come further down the chronology that goodwill was also, in other words, the value of the brand was also of interest to Acon. So it was an attractive feature.
With the goodwill there, I mean, you be careful. I mean, the goodwill there is plainly the goodwill in customers who
Yes.
buy kits or buy tests with the name Hughes Healthcare on it.
Yes, it was. But
So he's talking there about goodwill.
absolutely,
Customers
he
for
is. And I appreciate that.
public.
Yes, and obviously I don't have the advantage, if it was one, of having been present at the trial, but from everything I've seen, the term goodwill was used at the trial in the conventional sense of customer goodwill in the orthodox. But the point I'm alluding to here is that customer goodwill can also buy you something which actually could be called goodwill, both in the normal colloquial sense and in a legal sense, can buy you some attractive force, if you like, with a supplier. Because if you've got a brand and that's valuable, and the supplier's in a position then through you as the distributor to take advantage of that goodwill, that's an attractive force for you. And put another way, if the supplier's considering,
Well,
should
that's-
I...
Well, it may be, but you'll have to take us to whether there are any findings
Yes.
that support that.
I understand.
I suggest it's the other way around, actually. It's the attractive force is that the partnership is attracted to Acon, not the other way around.
When your lordship sees the materials that I have in mind, which the judge referred to, I hope my point will become a little clearer.
I mean, obviously you're going to come on to the point. Is your point that really related to the volume of sales? That from the point of view of a supplier, if they've got a customer who's going to generate a lot of sales, that's a value to them.
Yes, yes, and if your supplier considering, should I stay with a particular distributor or find someone else, the fact that the distributor has built up its own goodwill in its trade name is going to be a factor that, by necessity, is going to make the manufacturer more likely to stay with that distributor.
But it's really just about likely sales, isn't it?
It's really about what's
likely sales.
Yes.
I mean, from a supplier's point of view, they don't particularly care how you achieve your sales, but if you achieve your sales, that's attractive to them.
In this respect, yes, of course. I mean, in a sense, the whole case is about a pipeline from manufacturer of test devices down to the ultimate consumer, the government or whoever buys tests, through a series of business intermediaries. You know,
the goodwill, but to put it in a way, I mean, the goodwill of the partnership is the attractive, that it attracts customers, you and I, to buy branded tests. The goodwill that Acon has is that it has a number of distributors, for want of a better word, which are attracted to buy its tests and sell them.
yes. The
goodwill goes down.
Well, it can go both ways, but I mean, the statutory phrase, of course, is I'm going to come on to this, so we will discuss it in a more structured way from my perspective later. But the statutory phrase is, of course, business connection. It's not goodwill. But if one was looking at it in terms of goodwill as being some sort of attractive force or some factor which generates a propensity to deal, be that a upwards or downwards, it's the same concept. It's something which generates a habit of dealing, as it was put in one of the cases. And if you have...
The habit of dealing is the customer goes to the supplier and says, I'd like to buy kits.
It can be both ways, my lord. It can also be a habit in a seller's market. It can be the seller's choice as to whom it sells to. So in the normal course, obviously, one typically associates the buyer as having freedom of choice. But that's not a given. There are markets where the seller, the supplier, has the upper hand because, for example, you're in the middle of a global pandemic and everybody is desperate for reliable tests. And there are a limited number of manufacturers who have the proven capability of making such tests. So in that case, it's important to have someone who sells directly into the market to have the goodwill of the supplier, because the supplier is the one who has the whip hand, and that's part of the background here. Now, we can see later on, and I'm just going to give you some cross-references because I want to come to them chronologically, but simply for the purpose of tidying up a note, that there were, on the judge's findings, significant attempts later on by Mr. Hughes to exploit, or in the word that we've used in this hearing, leverage, control, or ownership of the Hughes healthcare brand in order to take over the business of the partnership. In order to make sales after dissolution. And I will, if I may, come to it in due course later on in my stages of my chapters. But just for the cross-reference, this is in the judgment, paragraphs 218 to 220.
That's 218 to 220.
218 to 220, paragraph 228.
Yep.
408, 410, 412, 416. I'm now going to move on to the second chapter, which is the relationship with Acon. And we can see how that started at page 96. Paragraph 54, an early priority for the partnership was to find a manufacturer of LFTs. And so the two partners engaged the services of two factory agents, a Ms. Pan and a Ms. Zhang. They were based in China, whom they'd used earlier when they were trying to find PPE, and that was to introduce them to potential Chinese manufacturers of LFTs. So even the sourcing of a manufacturer is something to which the partnership devotes its resources by engaging agents. And the judge goes on to say, since JH and PM regarded the securing of a government contract for the supply of LFTs as the significant prize at which they were aiming, it was crucial that the partnership's chosen manufacturer should produce an LFT that the UK Department of Health and Social Care, the DHSC, would be prepared to purchase. And before that could happen, the LFT has to pass assessments at the UK's science campus, as the judge calls it, Porton Down. Quite well known. Over the page, Mr. Hughes and Mr. Manduka were initially minded to purchase test manufactured by Oja Bio, obviously another manufacturer, but Porton Down rejected that. They had to rethink the question of which supplier to use. They concluded Acon's test had the best prospect of passing a Porton Down assessment, and the partnership purchased its first test from Acon on 18th of November. And then they later found out that Acon was paying $10 cents commission on each test, on the basis that Amy and Jasmine, the Chinese factory agents, had introduced Acon to the partnership, and that was passed on in the form of a higher sales price. And so the conclusion in 57 was that by the 18th of November 2020, the partnership had a supplier of LFTs in Acon. Can we go forward at that point to page 108? Because there's rather more to it than simply the introduction, important though that is, an introduction effected through the resources of the partnership. Page 108, para 116. Bottom. So the developing relationship with Acon, scientific evaluation of Acon's tests. The judge repeats that the Acon's LFTs couldn't even be submitted to the procurement system unless they passed an evaluation at Porton Down. And in November 2020, and this is important, Acon's tests had been suspended from the phase 2 evaluation at Porton Down. Mr. Manduka persuaded officials at the DHSC and elsewhere to permit Acon's tests to rejoin that process, and his son helped with that process. Over the page, once readmitted to the Porton Down process, Acon's tests performed well. Got through the phase 2 evaluation in February, and then next phase in March, and by the 27th of April, it had completed all necessary stages of Porton Down's validation process. Culmination of the Porton Down process meant that Acon's LFTs could be sold in the UK to professional entities who could administer those tests in a professional setting. So there was a period where even for a lateral flow test, you had to go and sit with a medical professional, a nurse or healthcare assistant or the like, and they would take the swab. But then the really critical step came with paragraph 118, that a further accreditation EU-wide obtained on the 14th of May. It's called the CE mark, and it's for self-testing. What that meant was that both branded and unbranded tests were certified to be suitable for self-testing at home and without the assistance of a medical professional. So at that point, you've obviously got a real advantage, and it's Acon that's been validated by the UK government and then has received a self-testing mark. And I should just note, going back to page 97, slightly out of the chronological sequence, paragraph 59, that sales were slow until mid-December, but in December 2020, Boris Johnson, still PM, explained what a lateral flow test was, and said that the country would need to rely on rapid testing to return to normality. So by the time you get to the spring of 2021, what's happened is that the partnership has found ACON out of obviously a universe of potential manufacturers. It's found it through its own agents that it engaged for that purpose. The partnership, as it happens through Mr. Manduka, has vitally persuaded the DHSC, the Department of Health and Social Care, to readmit ACON into the government testing process. That's paragraph 116, through which the ACON test then successfully passes. It had to be put back into the process. And then it, having achieved validation, it can then be sold on the basis that it's got UK government approval, and once the CE mark is approved, it can then be administered by anybody to themselves, resulting in a valid...
I don't suppose it matters, but does the CE mark have any significance in this country? And as I understand it, most of the sales were made in this country. Does it have legal significance? That I don't know, but because we weren't in the EU anymore, were we? Or were we still? I forget.
No, we weren't in the EU, but we did have the benefit of the CE mark nonetheless is that it's been given official status, at least in the EU, for self-testing. So from a marketing point of view, that's a benefit. And over the break, I'll see what other information there is in the judgment that helps us to understand the significance of that. We'll just give a moment. What I wanted to then show you was page 118, paragraph 154, which in a sense comes to the commercial point. Sorry, that's 116, forgive me, a wrong page reference. Paragraph 154, page 116. Second sentence beginning on the third line. Following the deal in February 2021, Newfoundland could purchase the market-leading ACON LFT. So the judge there making a finding that ACON was market-leading. The next feature of the relationship goes to the question of exclusivity. And again, I'll be addressing this when I come to make my submissions on the critical issue of business connection. Obviously, I don't accept that it is a legal requirement of what is business connection within section 29, that there should be exclusivity, either legal or factual, between the partnership and the third party. So I don't accept, if indeed it is submitted, I'm not sure that it is, that is something that should be read into the statute or is an inherent feature of what is business connection. I don't accept that any more than one would accept it for a customer in the normal case, with whom there can be no doubt there is connection, valuable connection, without any form of factual legal exclusivity. But nonetheless, there is quite a lot of evidence which it will be helpful for you to consider, and findings about exclusivity and documents that underlie them. And you'll see at the bottom of page 109 that the partnership pressed
Sorry, which
109
page 109 or paragraph 109?
Page, very foot of the page.
Yes, that's it.
That the partnership pressed throughout its relationship with Aecon to be Aecon's exclusive distributor in the UK. Aecon blew somewhat hot and cold on this question. Aecon attached some value to its relationship with the partnership. So just pausing there, the judge finds that Aecon attached value at that stage, as the partnership was selling via Newfoundland a good number of its NFTs. Aecon also thought that the partnership had delivered tangible value in helping to secure its readmission in the Porton Down process. That's what we were just looking at in para 116. However, Aecon never conferred on the partnership the contractual status of exclusive distributor, whether in the UK or in any other jurisdiction. What the judge is referring to there is the right to be exclusive for the jurisdiction. He goes on to say the closest Aecon ever came to conferring any degree of contractual exclusivity was in 2 letters, both dated 21 January, both sealed with Aecon's official seal. First letter, which he calls the letter of notification, was addressed to dear valued partner without specifying which anything was being addressed. It confirmed that Aecon had decided to grant the exclusive agency of its LFT, quote, to a single partner in the United Kingdom for all projects related to the DHSC government channels and all related business activities. So that's a statement that for holding out, that for DHSC business, in other words, government procurement, UK government procurement, the partnership had exclusive agency. And 125 is called the letter of confirmation. It was addressed to whom it may concern, but clearly intended to be read by the DHSC. And that stated that Hughes Healthcare is Aecon's exclusive partner for the distribution and supply of its LFTs in the DHSC UK government channels. And it states that this exclusive partnership was agreed in November 2020 and hereby formally confirmed in writing, and it will keep valid until December 1st, 2021, unless terminated in advance with mutual consent. So, although the judge doesn't decide, as he says in the next paragraph, whether that is conferred the exclusive right, i.e. the question whether that was legally binding, we say the judge himself records the statements made, which on their face are, as a matter of fact, statements of exclusivity for the partnership in relation to DHSC supply.
Can I just remind myself for a moment on that? So this relates to DHSC supply, and
This relates to
DHSC supply, and we see from the next paragraph that the partnership became aware that Aecon was proposing to supply to other people, and in the event Medco won, remind me when Medco won.
They won on the result of the tender was announced on the 16th of June. 2020. Yes, and I'm going to take you to that correspondence. So
one after the
I beg your pardon, my lady.
well, the tender, the Medco won in June 21.
Yeah.
So
So-
there was already a dispute by that stage.
Yes, they
because
got
of the process.
So just exploring the other aspect one moment. So by the middle of June, if this is of any value to the partnership, it's because it's got a cause of action. It's not because of any goodwill. Not because of any exclusivity for the future. The deal with the government has been done, there's no prospect of the partnership benefiting from this exclusivity except by bringing legal proceedings.
Well, unless there was another DHSC procurement exercise during the period of the governed by the letter, which ended in December 2021.
Medco must presumably have already agreed with ACON to use its kits to supply the government, the DHSC. I mean, that would have been part of the tender.
One would assume so. Yeah.
So, I mean, ACON may be saying one thing in its letters, but seems to be doing another.
When we look at the letters, we'll see the way that ACON played it, which the letters that pass back and forth, which the judge refers to.
Yeah, but whatever it said in the letters, it would appear that Medco must have tendered
Yes.
on the basis that it would be supplying ACON kits, and presumably
Yes.
it had some basis for doing that.
No, I understand that.
Yeah.
Yeah. The just to take it forward before we look at those letters, paragraph 127 on page 110 is how the judge sums up his conclusion in relation to the issue of exclusivity. He's satisfied. So having said I'm not going to decide that whether or not there was legal exclusivity, he says, I am satisfied that ACON was selective about who it supplied. And I rely on that selectivity, but I'm going to just take you through the rest of the paragraph. ACON's business model was to supply LFTs to a relatively small number of distributors in various jurisdictions, including the UK. It wasn't generally interested in selling LFTs direct. So ACON was not, as we'll see explained in more detail, a source of supply that was generally available. So you've got a market-leading supplier, ends up with UK government validation and a CE mark, and it's not generally prepared to make supplies to people who want to purchase from it. And the judge points out and finds at subparagraph 1 that that is how ACON behaved in practice. And he says, when customers sought to circumvent either the partnership or Newfoundland, AA, so she was the contact point, original contact point, and Scully tended to, working for ACON, she tended to refer those customers back to the partnership or Newfoundland, as the case may be. And it did that even when people such as Nabil Sheikh, who had strong internet distribution channels, made contact directly. And then secondly, he says it's consistent with evidence that he accepted that at the end of 2021, ACON had only 3 distributors in the UK, one of which was Newfoundland, one was Medco, who were selling to the DHSC, and then Mr. Hughes' new company, MSDL, which had taken over the partnership business, as the judge found. And then he goes on at little 3 over the page to refer to evidence from Freddie Manduka and Dan Butcher. So Mr. Butcher was in effect, the key salesperson who came in after Mr. Hughes dissolved the partnership, Dan Butcher. And he says they both knew a great deal about the sale of LFTs, both commented in their evidence on the importance of the relationship with Acorn to the business of the partnership, and by extension that of Newfoundland. FN, Mr. Manduca's son, Freddie, described it as gold dust. Mr. Butcher accepted that the relationship was, quote, the lifeblood of the partnership's business. If it was straightforward for competitors to obtain a supply of LFTs from Acorn, they would not have expressed themselves in that way. And then he goes on to say Acorn could afford to be selective. They were manufacturers of a market-leading test. It made little commercial sense for a manufacturer to agree to supply anyone who made contact with them. Now, the finding about turning away is important. If you go to page 104, paragraph 92, you can see that the judge finds that and halfway down, as will be seen later in this judgment, I should start in a similar vein, it's the middle of the paragraph, some customers would have been contacted previously by a member of the partnership sales team or by Newfoundland and attempted to circumvent the partnership by making contact with Acorn to see if they could purchase LFTs direct. As will be seen later in this judgment, Acorn frequently referred such attempts at circumvention back to the partnership. And prospective customers who attempted to circumvent the partnership were also good leads. At page 154, paragraph 342, one can see reference to a company called Argyle Rose, whose principal is somebody called Nabil Sheikh, which was a large online distributor of COVID tests, which had good Google presence. And he writes on the 15th, Mr. Sheikh writes on the 15th of February to Acorn, saying he's one of the largest online distributors, asking to buy direct. And AA, that's Acorn, forward the email to Mr. Manduca, and he forwards it on to his son. Let me know how you progress. So that's passing on the lead. Now, we say that's significant because such behaviour is different from a normal supplier, typical supplier, who might more naturally take the attitude, let them all come. And one could describe it as loyalty to the distributor, obviously for Acorn's own purposes, not an act of benevolence. But that's always going to be the case, that somebody's going to act for their own purposes. At this stage, I want to just ask you to look at the exclusivity letters. Those are the letters between the partnership or partnership's lawyers and Allen and Overy, and you'll find those in the agreed supplementary bundle again. They actually start with one which should have been in the agreed bundle and I think by mistake was omitted. So with apologies for asking you to dot around, can we go to our supplemental bundle, tab 3, page 10. So page 10, Thank you. Page 10. So, Gardner Leader refer to the confirmation letter in the second paragraph. Agreement reached to form an exclusive partnership for UK government channels for antigen tests. We understand you're already aware of our client's concerns regarding the prospective breach of our client's exclusivity to sell the tests because of someone called Pharmaceutical Direct Limited. We're instructed...
Just to be clear, that's different from Medco, is it?
Yes.
Yeah.
We're instructed that in light of the prospective breach of exclusivity, you have offered to pay our client 20 cents, US cents, for every test sold by PDL. So some form of compensation. As already communicated to you, this is unfortunately unacceptable to our client, given the exclusive rights. We hope it's all a misunderstanding on PDL's part that can be resolved without any formal action, not least because our client greatly values its ongoing relationship with you. What they say is we're awaiting PDL's response, a third party, and hope that that will bring it to an end. So that's the start of the correspondence, and that letter is referred to and summarised by the judge, and I needn't take you to it, in paragraph 126 on page 110. And then we can go back to the agreed bundle, page 2, and pick up the response. On the 6th of May, paragraph 2.
Just pausing at 1. So there's reference both to Medco and PDL there. So I assume that the partnership had understood that Acon was willing to sell to either Medco or PDL.
Mm-hmm. Your client appears to be under the misapprehension that he'd entered into...
There's an intermediate letter of the 22nd of April. Do we have that?
No, I don't think it was, I'm not sure it was referred to in the trial, but your client appears to be under the misapprehension that it entered into an exclusive distribution agreement with our client in November 2020. They don't dispute that they discussed an exclusive distribution agreement, but they do dispute that it formed a binding exclusive distribution agreement. Rather, such an agreement, I'm reading from paragraph 4, was an informal understanding between the parties that your client would exclusively distribute Acon's products to DHSC channels in return for its assistance in facilitating the process. Both parties understood that the option remained open to formalise this informal arrangement in an exclusive distribution agreement in due course. In particular, once Hughes had demonstrated its ability to generate large order volumes from the DHSC, but no binding obligations had yet been created. And then they set out their extracts from some further correspondence to the effect that there was still negotiation about exclusivity. That's in paragraph 5 and paragraph 6.
In 6, they say that they had internal policies no longer permitting it
Yes.
to enter into exclusivity arrangement.
Yes, that's right. And then the partnership didn't object. We'll see how that's responded to. So they say then that they obviously reject the assertion, but paragraph 9 they do make some relevant comments about the relationship. Both parties have already devoted considerable time and resource to their collaboration in the UK market. We trust that your client recognises the considerable benefits to it of its collaboration with ACON. It wishes to continue that collaboration. So, again, they dispute legal exclusivity. They say that as of now we have a policy that prevents us. They don't dispute that there was what they call an informal understanding of exclusivity. What they don't say, however, is we can supply and we will supply to anybody and everybody. So it's important not to get hung up, as it were, on the concept of exclusivity as if that was some sort of touchstone in the commercial world, and this is what the judge found, was that there's something which is, if you like, close to exclusivity, so where a supplier is selective.
Well, but you made a point earlier about, as I understand it, the partnership's focus, real goal is to get a UK government contract. And you've now got facts where, far from exclusivity, ACON has agreed to supply not just to one bidder for a government tender, but two.
Yes, well, even
Marked, isn't it?
yes, I understand, but the point I'm making is that you can have a business connection with somebody, and I'm going to be making submissions about this in due course, which is a meaningful connection, a meaningful relationship, even if it falls short of complete exclusivity.
I mean, I quite follow that this is a solicitor's letter and so on, but what they actually say is A, they're not allowed to have exclusivity arrangements, and B, they like this collaboration provided your client stops making incorrect suggestions. In other words, stops claiming exclusivity.
Yes.
And you obviously didn't do that until the end of the partnership.
Well, let's carry on and look at the correspondence to see how it developed. Obviously, they would prefer ACON. They would prefer the partnership not to try and disrupt their attempts to use alternative sources, alternative channels rather, alternative distributors. It doesn't follow that one should take their statements about the value of the relationship as being worthless.
No, I mean, I follow that, but you say, well, I want to attach weight to the expressed valuing of the relationship, but I'm going to discount the bit where they say we want to keep it up so long as you stop claiming exclusivity. I'm not sure how much the letter assists you.
Let's look at the Gardner Leader letter.
Yes.
The Gardner Leader letter in response at page 4 first of all points out at paragraph 4 that there was unequivocal confirmation in a letter which was that, to whom it may concern, so a holding out. They then go on to say that the page 6 on concluding an exclusive agreement regarding the DHSC channel, our client continued to expend significant effort in facilitating the authorisation of the tests. They continued to push for UK-wide exclusivity. Your client continued to acknowledge the exclusive commitment it made to our client, and then set out some emails. You can see the trust from ACON already from the exclusivity we gave you for the DHSC channel. and so paragraph 18 may point out that the later references where exclusivity was still being discussed and negotiated were in relation to exclusivity for the UK as a whole, which wasn't resolved. And then they go on to say, page 7, paragraph 23, they want to continue the productive collaboration.
Having threatened legal proceedings, reserved rights and everything else in the previous paragraph.
I'm sorry, my lord.
Having threatened legal proceedings again and reasserted their rights to what they say is an exclusive arrangement. In other words, not taking up the invitation made by ACON to desist. They're actually reinforced, strengthened, and then legal proceedings are threatened in 22.
Because I suggest they were able, the partnership correctly recognised that it had a value for ACON because it was successful in selling ACON's products and had previously been successful in getting ACON through the government testing process. So
ACON takes the view that it's of value to the partnership, i.e. the relationship with ACON is of value to the partnership, and says the partnership stop alleging exclusivity, and provided you do, we value the relationship going forward, but they don't.
Both sides, in a sense, are playing a degree of hardball, but it doesn't follow from that that they don't both, in fact, value for their own purposes the relationship.
In terms of, as you say, ACON was selling a lot of tests to the partnership. Is it right that overwhelmingly those were actually passed on to Newfoundland with a penny uplift? So once the relationship with Newfoundland broke down, what was there left in terms of sales by the partnership?
Once the relationship with Newfoundland broke down, what the partnership could still do was not only continue to target the bigger corporates, which was ever Newfoundland, but also continue with its efforts to obtain governmental sales.
Well, we've seen what's happened about the governmental sales.
No,
but
we saw, with respect, my lord, we saw what happened to one particular government procurement process, which was the tender that was completed on the 16th of June.
Yes, well, the target seems to be the UK government, and we see what happened in relation to that tender with the UK government. But just coming back to the main point, you say ACON valued the partnership because it was selling all these products. What proportion of those products were not Newfoundland at the point that relation in June 2021?
There isn't a finding about that, my lord.
I mean, roughly, do we have any feel?
I can't answer the question. I can try and find out, but I can't.
I mean, was there much apart from Collinson's? Do we know?
I don't want to just start making assertions without checking, my lord. So let's see it. Let's see what we can say in due course. But just wanted to take you to the next Allen and Overy letter.
I mean, would I be right in characterising sort of 21 as to 23 of page 7 as sort of the partnership or garden leader doubling down on the stance as regards ACON, and far from desisting as ACON asks, they double down on it.
I put it slightly differently, my lord. I think the partnership's maintaining its position. It's not residing, but it's also making the point that it wants to continue collaborating, and both parties, while taking a different view, as can perfectly well happen within the context of a relationship, a productive one, are taking their own views, but expressing quite strongly their willingness to continue with each other. But put another way, what you don't get from this is a sense of, well, if you're going to take that view, I'm off. We're going to end our relationship because we're falling out. And so despite the fact that there is a disagreement, nonetheless, both parties carry on dealing with each other. Acorn carry on supplying.
It's not quite the way I read. I mean, paragraph 9 of page 3, Acorn shares that wish, i.e. it says, we trust that your client, the partnership, recognises the considerable benefits to it of its collaboration with Acorn and it wishes to continue. Acorn shares that wish, provided that your client ceases making incorrect suggestions as the basis of its relationship. Well, far from ceasing making those suggestions, the Gardner Leader letter reasserts them.
Yeah, but
So, I mean, the proviso is not met. I mean, am I right also in thinking at this time in 2021, I mean, what's lying behind all this is that the world at large realised that lateral flow tests needed to get out there to keep to stop the pandemic. And so there was a big push to have both vaccines and tests very widely available.
yes, I mean, that lateral flow test wouldn't stop it per se, but they need to cope better with it. The pandemic. That's right. But despite the fact that there was disagreement, what had been affirmed in both sides' letters was the value of the relationship. If we look at the Allen and Overy response to that, which is on the 2nd of June at page 13, so having repeated, I needn't go through it, all of the statements about it not being a binding contract, at page 16, paragraph 19, our client is heartened by the willingness of your client to continue its partnership with Acorn. Now, the value of that relationship with Acorn, that existing channel of supply, as the judge found, Acorn was selective and it allowed the partnership to buy from it. The value of that was underscored by actions that Mr. Hughes took. So if you go to page 114 in the core bundle, this is during the period of what the judge called the row between Mr. Hughes and Mr. Manduka in February 2021. Paragraph 144, more serious, says the judge, was an email that Mr. Hughes sent AA, that's the Acorn representative, on the 22nd of February. He claimed that he had found out that Philip and Ararin intend to pursue the purchase of kits through Newfoundland at the same price. He said that he had discovered that Mr. Manduka, quote, was a fraudster, has conned people out of a lot of money, said that Acorn should apply to supply Mr. Manduka with branded LFTs. He didn't tell Mr. Manduka that he'd sent this email. He sent it to Ms. Blythe. In 146, the judge found that email was unfair to Mr. Manduka. Mr. Hughes had not found out that Mr. and Mrs. Manduka intended to purchase branded tests from Newfoundland. He just had a suspicion that that might be their plan, and then he'd heard some comments in an online forum and some gossip at a golf club, which, as the judge found, fell a long way of demonstrating that Mr. Manduka was a fraudster. But at paragraph 148, the judge said, the email was an attempt by Mr. Hughes to sow doubt in Acon's mind about Mr. Manduka's propriety, so that if he and Mr. Manduka ceased business together, Mr. Hughes, rather than Mr. Manduka, would have the benefit of the Acon relationship. And this attempt emphasises how important a relationship with Acon could be to anyone seeking to sell LFTs in the UK at that time. Now, we then go forward to the actions of Mr. Hughes in June. So the judge, just to be clear, declined at paragraph 147 to find that that email was the start of a conspiracy, which was the allegation that was made.
Just for my note, is that email in the bundle?
I don't believe it is. I can obviously produce it. I think it's been fairly fully extracted at 144. So the judge did, by contrast, find that there was a conspiracy in June, as my lords and my ladies know. If you go to 124,
Page 124.
yes, page 124, paragraph 200. So this is immediately after Mr. Hughes starts to put in motion what the judge found was his plan. So he switches off the emails, etc., for the Mandukas. And at paragraph 200, he exchanges WhatsApps with a Ms. Shui, who's taken over from AA, Ms. Ascali. So she's the new Acon representative. And he writes that they've secretly set up another business. This was his, as the judge found, erroneous, Mr. Hughes's erroneous interpretation of Mr. Manduka's incorporation of a company called Hughes Healthcare Limited, which was actually, as the judge found, pursuant to an agreement reached between the two partners. So innocent and in furtherance of the partnership business.
Yes.
No, yes, my
Not,
lady.
not in the name of Mr. Hughes.
No, but the absolutely no finding that there was any sinister intent. So I'm afraid that everybody is stuck with that, and no reason why there should be any resistance or suspicion about it.
I mean, Mr. Hughes, as you say, got it wrong. Actually, Mr. Manduka had, in flagrant breach of his duties, arranged to obtain a secret profit from Newfoundland.
Yes, he had agreed to receive a percentage from Newfoundland, and the judge found that was a breach of fiduciary duty.
A flagrant one.
Well, the judge didn't call it flagrant. I'm not going to bandy adjectives with my lord. Obviously, it is a meaningful breach of fiduciary duties. We'll come to look at what exactly the judge did find. I'm not going to minimise it. The question is, what's the impact of it? Here we're looking at something which, as the court will appreciate, it not only features in terms of the significance of the Acon relationship, but as I will draw the threads together shortly, is misconduct by Mr. Hughes. So at this point, pre-dissolution, and Mr. Hughes acting as it happens under a misapprehension about Hughes Healthcare Limited, which is properly and innocently incorporated to assist the partnership. misunderstanding, along with others, then leads Mr. Hughes to write to the key supplier on which the business of the partnership depends, to say that Mr. Manduka has been misbehaving and he can't do cheating. We'll look at the messages in a moment. The judge then records that Ms. Shui queries which entity holds the IP rights for the Hughes and Hughes Veritas brand. So Hughes Healthcare brand is what the sales have been made under. And Mr. Hughes replies, Hughes is with me. And that, of course, is incorrect because, as the judge had earlier found, and that was paragraph 52, Hughes was not with him. The right to trade, I'm reading from page 96 again, the right to trade under the partnership's chosen name of Hughes Healthcare was an asset of the partnership, not of HGL and of Mr. Hughes's company.
The judge does find, if I understand it, the judge finds that that wasn't a deliberate mistake.
Yes, he finds that there was. Yes, he finds that there was some sort of element of confusion, but nonetheless, the whole context is Mr. Hughes has opened up a back channel, private communication on matters central to the partnership, denigrating his partner, Mr. Manduka, and making incorrect basic assertions in response also to a query from ACON, an important query about which entity holds the IP rights. And that necessarily shows that ACON were interested in, as something of value to them, in the value of the Hughes brand.
Well, does it show that? You may be going to take us to the emails. Is another, because I'm not sure the judge makes any findings about ACON's interest there. Another might be that ACON doesn't want to be on the end of an IP.
Doesn't want to be. On
the end of an infringement suit.
Well, indeed, but the two go together, don't they? With respect, I mean, if the brand is of no importance, then you can just sell under some other brand.
But this is an arrangement where ACON is manufacturing tests and labelling them. Hughes Healthcare, as I understand it.
Yes.
It wouldn't. No manufacturer would want to do that if it thought that was going to result in litigation. So maybe you'll take us to the relevant material, but I'm not sure you can necessarily conclude that what ACON's interested in is the value of the brand, as opposed to the defensive point about not being in.
Well, unless ACON is
breach of a trademark.
Isn't the position that this one? I mean, unless that brand has some value in the market and therefore value to ACON, it would be a totally academic question because ACON could simply supply using some different brand or using its own brand. And the judge has found that goodwill had built up in the Hughes Healthcare brand. So the judge positively made that finding, and ACON are reflecting that in their query, which they would only make if it was of practical benefit in making sales into the market to carry on using that brand. And Mr. Hughes, in his, the judge in doing that, let me just finish off the paragraphs I was on. It refers in 202 to the goodwill that the brand name had generated. He then says he believed his statement to be correct, as my lady pointed out. He had an imprecise notion. Paragraph 203, still on the 15th of June, that Ms. Blythe emails ACON to order NFTs. Can you please invoice Hughes Group? This is the only account we'll trade. And the next paragraph, Mr. Hughes signs a new agreement with Mr. Butcher, in which he, so privately to him and Mr. Butcher, describing it as a division of the business as a division of his company, Hughes Group Limited. And then if you go forward to 129, paragraph 228, the judge concludes that the claimants have right to assert that Mr. Hughes and Ms. Blythe formed a plan to dissolve the partnership and take over its business from around the 15th of June. He took care to tell Anita Shui what he thought was going on and to assure her that Hughes is with me, as he realised that securing a supply of Hughes Healthcare branded tests from ACON in the future was crucial to his ability to continue the business. So the business that he has depends crucially on having Hughes Healthcare branding, and that's why he then contacts ACON. So both the brand and the relationship with ACON are what is crucial. Now, the next heading I was coming on to, which we've looked at a little already, is the main focus of the business. And this is important, both to set Newfoundland in context and to see what eventually matured in terms of the Danish deal. So there are a number of references which the judge has made to the real prize of the business being as seen by the partners when they set it up. Not the only focus, not the exclusive scope of the business, but the if you like, the main prize being sales to government, and one can see that at page 94, paragraph 40, which we looked at earlier.
Yes, that's the UK government, isn't it?
Yes. And then page 96, which is not, well, it's just a government contract, although I accept he goes on to refer, para 54, to refer to Port and Down.
Sorry, I think I missed your reference. Which paragraph are you on there?
54, my lord.
54, yes, I see.
63, page 98. Gets into even more detail. It was agreed at the outset that he and Mr. Hughes, start of 63, would focus on generating sales to the government and large corporate entities, whereas Freddie Manduka would focus initially on universities and schools and then later individuals and small businesses. I accept that as an accurate high-level statement of what Mr. Manduka and Mr. Hughes considered to be a sensible demarcation in theory. Both Mr. Manduka and Mr. Hughes thought at the outset of the partnership that obtaining a government contract would be the real prize. And then at page 106, 103 sub 2, that where the judge says that Mr. Hughes and Mr. Manduka weren't focused on the smaller Newfoundland type of customers.
Sorry, 103 sub 2.
103 little 2.
Thank you.
And what happened was that the Danish opportunity then arose and was in effect in the same category because of its potential magnitude as a UK government contract. And the judge deals with that in detail, but in a much later section of his judgment, which starts at page 162.
Just thinking right ahead to where we might end up in the end. The judge's decision, as I understand it, turns on the relationship with Acon. Is that fair?
The section 29.
Yes.
Yes. Well, sorry, it turns on the, in relation to the Danish deal, if we just break it down a little, my lord, it turns on a multi-factor analysis that the judge sets out in detail and which goes beyond simply the relationship with Acon, as I'm about to show you.
Well, I follow that there is all this stuff, explanation of what happens with the Danish government. I'd just like to understand where it fits into the overall argument. If the judge had concluded that the Danish deal was a maturing business opportunity at the point of dissolution, then you would have an independent ground of claim. But you accept he didn't decide that?
No, I accept that, or rather, I accept he didn't reach a finding in the form this was a maturing business opportunity in the form ultimately transacted, which is the phrase he uses and underlines in his judgment. So he's very careful to describe it, to limit his negative finding, if I put it that way, in that way. What he does find is that it was an opportunity, and he makes a number of other findings about the way in which that opportunity existed and its status as at the date of dissolution.
I think I'd like to pin you down a bit further. So the business connection he finds is Acon, is it?
I'm sorry, my lord.
His finding in favour of your clients on section 29 is based on Acon being a business connection.
Yes, it's based
nothing to do with the Danish government. Is that right or not?
It's based on the Danish deal flowing from a number of factors, which included both the Acon business connection and the steps that the partnership had taken, which involved other connections in Denmark. So it's not only...
Well, we'll obviously have to come to this.
Yes.
I had understood that the judge was really basing his decision on the connection with Acon. You say that's not right.
It's part of it. We're going to have to look in some fine detail, my lord, because otherwise I think there's a risk of oversimplifying what the judge found in paragraph 395 of his judgment. But perhaps it would help if I took your lordship. I appreciate the point, of course. I'm not trying to be unhelpful, but perhaps it would help if I took your lordship through the facts that the judge found.
Yes, let's do that.
And then it may be that the answer will become a little clearer. So we're on page 162. You can see paragraph 384. That Mr. Butcher had a contact with Chris Rawlinson, and in February...
Can I just put this, just to be clear, chronologically, this is sometime after dissolution of the partnership?
No, it's dissolution was June 27 June.
Yeah. And
sorry, it depends what you mean by this, my lord.
Okay. We're in a section which starts at 381.
Yes, that's after.
And and talks about the Danish deal resulting from what the Danish government considered to be a medical emergency at the time. The emergency is in November 2021, because there's a spike in COVID cases in Denmark, and unless I am chronologically challenged, November 2021 is after the dissolution of the partnership by some months.
We were at cross purposes. I was talking about paragraph 384, which is what I just taken.
I was trying to put it into context because, okay, right, if we're at cross purposes, I accept he goes back, but this is the whole section is dealing with something which happens in Denmark later after the partnership is dissolved, which, picking up my Lord's point, ultimately leads, I thought, to the judge concluding that the Danish deal was not a maturing business opportunity at the time of dissolution of the partnership.
The judge is very careful in the way he describes his findings. He says that it's not an opportunity. It's at the top of page 168, paragraph 401(6). I conclude that there was no opportunity to pursue the Danish deal in the form ultimately transacted at the time the partnership dissolved. But he goes on to say at 404 that the mutual confidentiality agreement, which is an agreement that the one that Mr. Hughes entered into with Mr. Butcher in the 15th of June, did not result in the Danish deal being an opportunity for Mr. Butcher to pursue. Rather, it was an opportunity that the partnership was entitled to pursue. So his findings can't be completely simply categorized.
Well, I see your point to an extent. Let's just take section 29 for a moment. Judge says, look at that relatively literally business connection. So we ask ourselves, what did the judge think the relevant business connection was? And if we go through to, well, 427.4, he says, I've explained that Acon was a business connection, and there may be others. And then in 428, he says, all of the benefits derived from a business connection of the partnership since they involved selling test purchase from Acon. And indeed, if you go back to paragraph 281, that's what he says amounted to a business connection. So is this fair that there is absolutely no finding that the fact that the Danish deal matured or that there was any prospect of a Danish deal had any bearing on business connection for the purposes of section 29?
The other part of the judgment that it's my fault, not my Lord's fault. I'm not sure I've understood the question, but before I try and do my best to answer it, could I draw your attention and remind you to page 164, paragraph 394? I'm afraid we're doing what I'd hoped to avoid, which is to get, before you've been reminded of the facts, to look at the...
No, I quite follow. We ought to go through the facts, but I'd like to understand where they fit in legally. As I understand it, you won on this point on the basis of section 29. That refers to business connection. The business connection that the judge identifies is Acon. There is no identification of Denmark as a business connection. Is that fair?
That's the point. There's an intermediary called CAP in Denmark, which has a distribution agreement with the partnership.
So does the judge say that that was a relevant business connection?
If you look at 394, I suggest the judge does find that, because he concludes at 394 on page 164, my lord.
So it's a mystery that when he comes to make his findings on section 29, he omits that.
You haven't got a respondent's notice, have you?
No, but I'm not sure that is a fair reading of his judgment as a whole.
Well, can we just look at the section 29 conclusions then? Paragraphs 424 to 428. Is there any suggestion that anything other than the connection with Acon was a relevant business connection for this purpose?
In 428, he says in the penultimate sentence, I have also explained other factors that led to these benefits being achieved, particularly in relation to the Danish deal. And that is a reference, direct reference back to 394, where he sets out in detail what the factors were that did lead to
Absolutely, and he's explained in the previous sentence that at least to an extent they derive from the business connection with Acon, but there's no suggestion that there was a business connection with CAP that justified his conclusion. I mean, I quite follow you.
I agree that, my lord, of course, I understand that if you look at that paragraph in isolation, the only business connection that he's identifying there, of course, is Acon, and we do say very strongly that Acon was indeed a business connection. The judge was entitled to find that. The point I'm pushing back on, with great respect, is that the judge does find that and it's a finding which is readily explicable when you look at the chronology in detail, which I was hoping to take, my lords and my lords.
And you must. But is there any finding that CAP was a business connection within the meaning of section 29?
No, there's not a finding in terms of that, but there is a finding that there is, in a general sense, the judge starts off 394 by saying that he finds that when listing the factors by which the deal came about, this is in the preamble to 394 on page 164, I comment on the extent to which they had some link to the partnership's business, property, name, or business connections. So he wraps it all up. And I accept it's not completely satisfactory in the sense that he doesn't say, I'm going to then separate out precisely which sublim anything belongs to, but he does then go on to say that, first of all, that CAP in little 2 was persuaded that Acon's test was a good one, and CAP had been introduced to the partnership through a connection with Mr. Butcher. And then the good performance of Acon's tests, this is little 3, which I'm trying to get to, that was a brainchild of CAP, but also an entity that had a contractual relationship in the form of the distribution agreement with the partnership. So that study was absolutely critical to what happened. And if I may, and I hope it will be helpful, I'd like just to go back a couple of pages just to show you how that came about and the key significance, we say, of the step that the partnership took to get the Acon test registered through the partnership's Danish distributor CAP onto the university study in Denmark, because that was the critical factor that enabled the Danish deal to go ahead. So let me try and just make that good. One can see that 384 on page 162, Mr. Butcher agreed to become involved with the partnership's business. He then contacts somebody called Mr. Rawlinson, and at that point, this is Mr. Butcher being agent of the partnership. He then asks Rawlinson to make an introduction, and one of the people who is introduced is a Mr. von Eitzen, a partner in CAP. And so he's introduced to Mr. Butcher, and then the managing director called Teresa Krausman becomes involved. And then 386, CAP and DB discussed an arrangement under which CAP would be paid a commission. They were interested in obtaining some measure of exclusivity, or at least being the primary contact in Denmark, Finland, and Norway. Before agreeing to arrangements such as this, they wanted to understand better the nature of the LFTs that the partnership was selling. So Mr. Butcher then draws on the expertise of Mr. Freddie Manduka and provides CAP with a Hughes healthcare report. And then they get data that Mr. Freddie Manduka has arranged, and 387, CAP were ultimately satisfied at the outcome of their inquiries about the test that the partnership was selling because they entered into an exclusive distribution agreement dated 13th February, expressed to be with Hughes Healthcare subsidiary of Hughes Group Limited. That agreement was, despite its name, concerned largely with questions of confidentiality. I've concluded that in part, CAP's agreement to enter into some business relationship with the partnership, so the CAP having a business relationship with the partnership, was informed by what it regarded as satisfactory answers to technical questions with the material that was used, that was prepared for the partnership. What mattered to CAP was the technical information. It didn't matter that the test sample Hughes Healthcare branding. After CAP entered into the exclusive distribution, it was Teresa Crossman, so the managing director of CAP, who shared with the partnership insight that participation in the university hospital study might increase the prospects of the partnership winning a contract in an anticipated competitive tender to supply LFTs to the Danish government. The partnership adopted that insight and passed it on to Acon, who was prepared to contribute some 34,500 to the costs on the basis that it was a Flowflex, as distinct from Hughes Healthcare tests that were included. Both Acon and the partnership, I'm dropping down 3 lines, thought that a successful performance in the university hospital study would increase the prospects of making sales in Denmark, generally not just sales following success in a tender process. And 389, that started in around March 2021. 390, it took longer to perform than expected. So just pausing there, what you have is a study which was going to validate tests from a technical scientific perspective, rather important down, as it were, which was being conducted in Denmark. And that study had got an Acon test on it, but that was arranged through CAP. And it was CAP, as the judge explains, who then were the contact, because they were, as the judge calls it, the registrant. And so, as the judge says in 390, because the rate of COVID dropped during the summer of 2021 before we had the Omicron variant, study took longer. Paragraph 392.
You can't just miss out the end of 391.
No, I'm not trying to miss out at all. If your lordship's referring to the interaction, so one can see various interactions.
Well, assiduous and diligent though this was, it had no effect at all on the ultimate securing of the Danish deal, which came as a result of the perception of an emergency situation in Denmark.
Yes, that's what he's referring to there is the updating that took place that he's referred to earlier in the paragraph, I suggest.
I mean, he later makes an express finding that, as I read the judgment, which is where I was, I'm afraid, that there was no opportunity to pursue the Danish deal at the date of dissolution because the Danish deal resulted from circumstances arising after the partnership's dissolution.
The finding, if you're referring to the one that I took you to...
No, I just read out the beginning of paragraph 403, which seems to be where the judge gets to in all this. First sentence of 403.
Yes, he says, but he's referring back to what he's already explained.
Are you, in essence, trying to challenge or persuade us that that summary that the judge sets out at 403 is wrong? If so, have you got a respondent's notice?
Of course, my lord, I don't. I'm not trying to persuade you that the summary is wrong, simply to look at the judgment as a whole, because the judge finds very specifically that there was no opportunity to pursue the Danish deal in the form ultimately.
Well, I know you emphasise the words in the form ultimately.
Well, he does. It's not.
Well, okay, but you place emphasis on the judge's emphasis. But I'm trying to pick up. My lord's been putting to you what I understood to be the position, which is that the Section 29 decision of the judge turns on the finding that Acon is a business connection of the partnership, and nowhere does the judge deal with the Danish deal in conventional fiduciary duty, maturing business opportunity terms. He just doesn't deal with it. In fact, he says quite clearly that's not what he's doing. And the reason I understood it to be is because he doesn't regard this as being anything that would give rise to an equitable remedy in conventional fiduciary duty terms. And that's because of his findings in 403. And I'm just trying to understand whether you're trying to get in behind that finding, and if so, on what basis. And if you're not, then fine, we can focus on what he actually says about section 29.
Yes, so just taking it in order, the actual order that the judge made at page 203 and 204 under section 29, paragraph 1 of his order.
Sorry, let's just look at that. Is an order that Mr. Hughes, paragraph 1 at the bottom of 203 in the order, Mr. Hughes, under section 29, and breach of fiduciary duty in respect of such failure to account, Mr. Hughes is obliged to account to the partnership for, level 1, benefits from the Danish deal to the extent that they were derived from the partnership's property, name or business connections. Now, the extent of that extent, the judge found or held, was obviously a matter for trial too. So the question is whether in his judgment he has found factors which could fall within that accounting in addition to Acon. Well, obviously I primarily rely on Acon as being a business connection and the flow of events, if you like, through that channel, but I do say with very great respect that there is also findings in the judgment, whether or not they constitute a maturing business opportunity, and I fully accept that the judge did not find there was a maturing business opportunity, but there are findings in the judgment which suggest that, and which I suggest should properly be interpreted as meaning that there was another factor, which was the partnership's placement through its Danish business connection cap, through its Danish contact cap, onto the study. Can I explore this a moment? First of all, I think it might be helpful for us to have the order setting the issues that were tried in this trial. I mean, in particular, it might help me to understand whether it's going to be open to you at a subsequent trial to run maturing business opportunity or anything like it, or whether that had to be dealt with in this trial. Secondly, I think I would find it helpful to have anything in opening submissions or closing submissions on your side identifying CAP as a business connection. And thirdly, I suppose it would be helpful to have anything on your side in opening or closing submissions maintaining that the Danish deal was a maturing business opportunity.
Certainly. I don't have to suggest that just to be clear about what my case is, I don't have to suggest that that it was a maturing business opportunity for it, and I don't suggest, and it's not my case that is that company law concept is the appropriate cut-off or criterion in partnership law.
I mean, the only finding in this order of any breach of fiduciary duty is in subparagraph 4 of paragraph 1, which just says, to the extent that JH failed to account to the partnership under section 29, he breached his general fiduciary law obligations.
Well, yes, that's also in one star, same point of the.
Yes.
And I have to say, I think the recovery partner's judgment would cast doubt on whether an obligation to account under section 29 involved any breach of fiduciary duty. But let's leave that aside for a moment.
Yeah, but I mean, as Moses picked up, there is no suggestion in this order that there was a freestanding breach of fiduciary duty finding independently of getting in through the gateway of Section 29. Perhaps I can try and put it that way. The only way you get into any of this is breach of Section 29, which I think is why my Lord's trying to bring you back again and again and again to what are the component elements of the quotes business connection that the judge relied upon under Section 29.
Yes, well, I understand. What the judge actually held, we should also look at subparagraph 3, Arabic 3, on page 13, on about a third of the way down, page 204, for the purpose of the obligation to account to the partnership under Section 29. The concept of the partnership's property name and business connections includes, but is not necessarily limited to, those matters set out in paragraph 427 of the judgment. So that part of the order, which isn't appealed, does allow us to take a general view on the extent to which any of the factors that are mentioned by the judge were within the overall concept that he mentions, property name and business connections, and property itself being quite a protean concept, as we'll see. And anything that falls within that is something that can be brought into the account.
Can I just go back to, on this point, go back to 428 and how you read 428 in the judgment, just looking at it with this. So, I'm looking at the order with paragraph 428. You rely on the order saying it's not limited to the things set out in paragraph 427, one of which is the ACON with the business connection. But I'm just rereading 428 and trying to understand what the judge is saying. The first sentence says, all the benefits received from sale of all those tests following dissolution were to an extent, at least to an extent, derived from the business connection. Refer specifically to ACON. Then he says, I have explained other factors that led to those benefits. Now, my reading of that, and I think your reading is different, which is why I'm asking the question, is, to me, the most natural reading of that second sentence is that those other factors are not business connections of the partnership, they're different things. And certainly, you say he's cross-referring to 394, and certainly a number of the things in 394 couldn't be regarded as business connections. And when you look at 394, CAP is referred to, but what's the focus, look at the words in italics, is CAP's persuaded that the test is a good one. Not that CAP is a business connection.
Well, that's level 2. I was looking at level 3. Where CAP is described as an entity that had a contractual relationship with the partnership.
So can I pin you down a moment longer? You've explained you're not pinning your colours to the mast of maturing business connection, because obviously it's not your case. That's what Section 29 means. You pin your colours to the mast of Section 29. You say the ACON position isn't determinative. Look at CAP. So which bit of Section 29 do you say allows you to rely on that? I mean, it's got to be property name or business connection, presumably. Which one is it?
I say that it's the participation through the agency of CAP in the Danish study was part of partnership property. Because I say property is whatever the parties expressly or the partners expressly or impliedly agree is property and has a...
What was CAP acting as the partnership's agent?
I beg your pardon, my lord?
So CAP was acting as the partnership's agent.
So they had the contractual relationship. Yes, they were bound by the agreement that the judge refers to, and one can see that that's exactly what CAP did.
The agreement is the one that the judge says really dealt with contract.
confidentiality, yes. So there's, but
Did it appoint CAP as agent for the partnership? But wait, sorry, you said a moment ago, I think,
yeah,
it was through the agency of CAP.
yes, through the agency of CAP, yes.
And are you using that expression in the strict legal sense?
No, I'm
or
using
are you
it.
not?
I'm sorry. I'm using the agency in the sense of that's what brought it about. CAP were the medium through which this occurred.
Sorry,
and
I was just trying to get
Yes,
whether
no,
we were using the word agency in
but-
the technical
but
legal
but
sense or not.
but they did have a contractual relationship. They were bound by mutual confidentiality
Right, but that
obligations.
wasn't an agency relationship in the legal sense.
Well, whether the judge didn't find it was what in law would be constituted an agency, but it may well have been something that gave rise to the substance of an agency relationship if a third party like CAP has an opportunity which it has been presented with by a principal for a limited purpose, then one would typically say that
So
is
was
an
it
agency.
pleaded or part of your argument at trial, not your argument, your side's argument at trial, that CAP was an agent in the legal sense of the partnership for the purposes of dealing with the Danish government?
I'm going to assume, unless I'm told otherwise, the answer is no.
And can I widen my previous request for materials bearing on what you said at trial about CAP as a business connection to all references in opening submissions or closing submissions to the participation through the agency of CAP in the Danish study being partnership property?
Certainly. We will do that and provide you with a selection of extracts, which I imagine is what is the best way of doing it.
From what I understand about the length of the closing submissions, I probably don't want the lot.
No, I was going to say you wouldn't welcome being presented with 200 pages on each side. But I was just going to show the court how the Danish deal emerged from this position, which I do say had been secured through the efforts of the partnership, through its, let us use a neutral term, contact, CAP, with whom it had a contractual relationship. Perhaps we can call it a contractor, although we're not in the normal sense. I don't want to get turned into contentious terminological discussions, but there is a test which is ongoing, and that test is a position that is secured, in my submission, on the judge's findings for the benefit of the partnership, because it comes through CAP, who are reporting to the partnership and who have no other interests, and they're under a confidentiality agreement. They can't do anything with the information they have, which would include, therefore, everything to do with this arrangement. They can't do anything except use it for the benefit of the counterparty, which is the partnership. And so you can see what happens, which is in 392, that a Danish procurement official, Mr. Prand, telephones Bent von Eitzen, who is the CAP executive. And the reason he called Bent von Eitzen was simply because CAP had registered Acon's test in the university hospital evaluation. And he had found out from the university at the bottom of the page which tests had performed well. And he had used the details of the registrant that university hospital had, which was CAP, to inquire about the possibility of purchasing those tests. And that registration was something which I submit, whatever the precise label for the legal relationship, was in a practical sense a business opportunity of the partnership of real specificity and real value, as it proved. And one can use an analogy or figure of speech. What it meant was that, assuming the Acon test did well, they were in pole position for the Danish government's procurement exercise, should the circumstances of the pandemic require it. So during the middle of 2021, the virus dies down, it's the summer, but everybody knows that unless and until the virus is vanquished or runs its course, there's a danger of future waves as the winter comes, and so it proved with the Omicron variant. And when that completely foreseeable development occurred, the partnership, through this registration, through its Danish business contact app, was there waiting to take the opportunity. And that's precisely what happened. And so, although
I mean, I find it difficult to square that submission, saying, well, everybody knew that there'd be this and this possibility of that, with what the judge says at 394 sub 1. I mean, the emergency situation had nothing to do with the partnership's business, its assets, or its business connection.
no, but the judge, with great respect, is correct. That it's the market, if you like, the potential existence of any market at all for this product. That depends on the arising of a wave of the pandemic and a requirement, in this case a sudden requirement, for lots of tests. So that's not the partnership doesn't have any proprietary or quasi-proprietary interest in the pandemic. I mean, that's all the judge is making, but that's the whole context in which the partnership is set up to exploit and to turn to commercial advantage. So that's simply the landscape, if you like, and then the judge is simply pointing out that it's obviously not in the partnership's gift in any sense at all whether the final need, the customer's desire for the product, will materialise. That depends on happenstance, whether there's going to be another wave of the pandemic and how severe and how quick it is. But if that should come to pass, and plainly that was the foreseeable position the partnership was set up to deal with in the first place, then in relation to this Danish government need, the partnership had managed to secure a highly advantageous and specific position for itself through its registration, through the medium of CAP, whether you call it an agency or not, through the medium of CAP on the university hospital study. And when when the ACON product then did well, that was going to result in a specific demand and opportunity that was going to come to the partnership. And that's exactly what happened, as the judge records in paragraph 393. So it flows from the university to the information flows from the university to the Danish government, through to CAP, through to Mr. Butcher, to the partnership. And that chain of events is already there, waiting to happen if the circumstances of the virus then bring it about, make it a real commercial need in due course, and that's precisely what happened. So, and then that culminates in an agreement on commercial terms, which is, as the judge records in paragraph 394, due to a cluster of factors, which include the handling of the negotiations. And I'm reminded that it's just a feature of the background, but that partnership property, as the judge records in the second sentence of 3942, had also been instrumental in persuading CAP to enter the ACON test into the study. So it happened through Mr. Butcher. Mr. Butcher himself, the judge records at paragraph 285 on page 142, maybe he didn't reach a final decision on that. A business may have been a business connection of the partnership. Sorry, bottom of 141. He describes it as page 285, middle one.
Sorry,
No, my fault. Page 141.
Yeah.
Very foot.
Yeah.
He said he's not going to decide. I'm sorry, I see that I omitted to remember what he said in this paragraph about CAP. he says it's arguable that Butcher, at least arguable that Butcher was a business connection of the partnership, and he imparted and received confidential information with a view to soliciting sales of NFTs for the partnership. In a similar vein, it's possible that Cap and Colin Phillips were also business connections, and I should have remembered that.
So can I just pin that down? It must follow from that that Judge did not base his decision on Cap being a business connection because he leaves the point open.
No.
Does that mean that the question is now historic, or does it mean that you can run it in the second trial, or what?
Well, I'm plainly the latter, with great respect. I mean, that's what the order, paragraph 1(3) says. So the section 29, I mean, just to leap ahead a little bit, the way I've analysed the judge's reasoning is that the failure to account under section 29 is a breach, obviously, of section 29 and can also be classified as a breach of fiduciary duty. So the failure to account, and that's consistent with the majority judgment delivered by Lord Briggs. Well, my lady shakes her head, but I'm going to make some submissions on that. So in my respectful submission, that is precisely what the majority found in disagreement with Lord Leggett in the Recovery Partners case, that there was the not paying over that constituted a breach of fiduciary duty. Lord Leggett strongly disagreeing, but not in the majority. But nonetheless,
so I think I follow. So whether or not on your case, whether or not there was a breach of fiduciary duty is entirely the same question as whether or not there's a duty to account under section 29. Absent a duty to account under section 29, no breach of fiduciary duty.
The way that I mean, on my case, yes, in a sense, but on the appellant's case, as I understand it, what's being said is that there needs to be some independent breach. There's a separate unwritten condition for section 29 to be read in from previous case law, as I understand it, that there needs to be an independent breach of fiduciary duty from what the words of section 29 is.
And I followed that there's that argument, but because this bears on some other argument, I'd just like to understand, on your case, absent, it all turns on section 29. If there's no breach of section 29, there's no breach of fiduciary duty.
The only reason I'm hesitating is that if there was no breach of section 29, could there nonetheless have been some other breaches of fiduciary duty? The judge simply didn't address the question in that way because he focused on the words of section 29 as constituting a self-standing test.
What law this seems to say, it doesn't find any other breach of fiduciary duty, as we've discussed.
Well, the judge seems to regard the failure to account as, he described it, as my lady pointed out, both as a failure under section 29 and a breach of fiduciary duty. Yes, in respect of such failure.
So just on my Lord's question, based on the order, the answer to my Lord's question is that it all turns on section 29.
It all turns on the failure to account.
Yeah, there is an obligation to do so under section 29.
My lady, I don't want to appear to be quibbling. As I read the order, he both says there's a failure to account under section 29 and a breach of fiduciary duty in respect of such failure. So the matter for interpretation is whether such failure means failure to account under section 29 or failure to account per se. As you'll see when I get there, obviously this is going to be a bone of contention between me and my lady. It's my submission that Recovery Partners shows us that a failure to account for profits which a fiduciary derives as a result of the fiduciary relationship, even after the termination, is itself a breach of fiduciary duty. Yes.
The majority says there doesn't need to be a breach of fiduciary duty to trigger the obligation to account. Exactly. So I think
yes, maybe it depends on whether you call that obligation to account a fiduciary duty in itself. In which case, I apologise. I hadn't.
That may be my fault.
Sorry.
I mean, I think we're getting all to the same place, just with different ways. I mean, the judge is quite clear, as I read his judgment, that he analyses this case as a case under Section 29 as a freestanding provision, which has no necessity to have recourse to any general fiduciary duty obligations. And he says that at paragraph 245, he says it at 253, and he comes back to it at 426 when he actually looks at Section 29. His conclusion is deliberately framed by reference to what I regard as the relevant questions summarised in paragraph 245, rather than by reference to the concept of maturing business opportunities, since I regard those as the right questions. And you can track that back, as I said, to 253 and 245. So my understanding is the judge got to his answer exclusively through an analysis of Section 29 and not through any independent analysis of fiduciary obligations, maturing business opportunities, or anything else. And the only breach of fiduciary duty that his judgment or order contemplates is the failure to account under Section 29, that having been, he says, established quite independently, just on its terms.
Yes, that I agree with. I thought I was answering facing a slightly different question, which was a sort of more abstract one, which is, could there, if you take out Section 29, would there be a breach of fiduciary duty in any event? Could you find one in any event? Would that be sufficient?
Well, the judge didn't, and you haven't got a respondent's notice.
No, we haven't got a respondent's notice. And just to be completely clear, I'm sorry if there was any failure to engage with what the court had in mind. Section 29 is a freestanding obligation, so that on that basis, and you don't need to read into it any test of separately finding an independent breach of fiduciary obligation. Now, there is perhaps a point as to whether on the judge's order, even if he was wrong about Section 29, not requiring a breach of fiduciary obligation, there would still be a basis for conducting the inquiry at trial too, because there is, on what I say is standard fiduciary theory, particularly following the recovery partners case, that there was still an opportunity that the partnership was entitled to pursue, and there was the use of what I say was the business connection with ACON. So the question of whether there is a breach isn't one that has been ruled out by the judge. He didn't say there was no breach. He simply didn't answer the question. So the impact, if my learned friend is correct, which we strongly dispute, of course, the impact of that is another matter on the judge's order.
I just want to echo this. I think it is echo what my lord said earlier about we need to see what the issues were for trial 1 as opposed to trial 2, because it may be, let's get some nods on the other side, if these were matters that should have been decided at trial 1, it's not really going to be open to restart the same exercise in
well,
trial.
I wasn't talking about restarting the same exercise. I mean, we've got findings of fact in trial 1, which would be the findings of fact that would, in themselves, so far as they go, would govern trial 2. And the question what conclusions you might draw of law from those findings is another matter. I mean, if the judge, I don't want to appear to be standing back from what is undoubtedly going to be our primary submission, that Section 29 plainly is intended to occupy the field of how a partner should account for private profits made from the use of, to use a broad phrase, partnership assets. And that it is, we say, absolutely not the case that there is some latent condition that must be engrafted on to Section 29, whereby you have to find independent conduct separate from the conditions specified in the statute to generate liability. So we say that the judge got that point absolutely correct, and that the relevance of looking at fiduciary duties is merely to make the point which the judge hints at as a matter of law, that Section 29 can be regarded as the embodiment of a fiduciary duty. I mean, it essentially declares and codifies what the fiduciary duty is in this context of partnerships. So, and that seems to have been the Law Commission's view, by the way, as well. So that there is there's no tension whatever between the concept of fiduciary duty and Section 29. And once you get that, then we do say that then the judge was broadly right, that it is a question of fact and degree, and having steeped himself in, to use the now cliched phrase, sea of evidence at the trial, he reached a conclusion that Acon was a business connection, and the reasons his primary findings of fact have not been challenged. It hasn't been challenged, for example, that Acon was selective about whom they supplied or anything of that sort. And having concluded that Acon was within the partnership's business connection, that on its own was enough to trigger liability under Section 29. Now, as I interpret the judgment, it is also the case that the judge left open other factors, and I point to paragraph 428, read with paragraph 1.3 of the order, to say that there are some points where further fact-finding will have to happen at trial too. And we will, of course, go back to the pre-trial order, but whatever that order precisely provided, and however precise it was, may not have been that precise from recollection, but this is where the judge has ended up. And I'm sure all the members of the court will have experience of split trials, that you can't always legislate with absolute accuracy at a CMC for precisely how it's going to look after you've had weeks.
We're often warned against them, and maybe it will turn out that this case is an illustration of it. I don't know.
There's a tension between the best way of doing it and the amount of costs that people are willing to incur, I'm afraid. But Whitehouse and Allen, I think, is the case that Lord Wilberforce, that my Lord has in mind, that yes, it's often been said that it's a shortcut that turns out to be a long cut. Here we are. The point I was going to make was to come back, if I may, to the Danish deal. I think I've said enough on the detail of that for the moment. Very briefly in relation to Newfoundland, the picture that emerges from the judgment is that sort of smaller sales were not the main focus of the partnership. As it happened, they became more significant relative to bigger sales, as at the time of dissolution, but very quickly thereafter, as you can see, and I'll show you in a moment, post-dissolution events, there were lots of sales, not only the Danish deal of 35 or 40 million tests in total, I think it was 43 million in total in 2 tranches, but 20 million tests were sold by Mr. Hughes after the dissolution, including to Waitrose and Boots and big corporates. So and those were never going to be things that had been within the. Perhaps I don't want to overstate it, but that was it. There were the big corporates, as we saw from paragraph 63 of the judgment, along with government, were what Mr. Hughes and Mr. Manduka thought they were going to focus on And Newfoundland was more successful at obtaining what were typically the smaller orders. So that's how that started and progressed. Now, what happened was that there was an agreement that the judge found, which I can just not take you to, but give you the reference to it. It's pages 105 to 107.
Pages 105.
Pages 105
Yes.
to 107, paragraphs 98, 101 and 105, which is what the judge calls the demarcation agreement. Not very surprising as to how, as between Newfoundland and the partnership, contacts with customers were to be allocated, and it depended on who'd had the first contact. So, and that also included what you might call sub-distributors, customers of customers. So if Newfoundland had first made contact with a distributor, and then that distributor had its own customer, and that customer then came to the partnership, that would then be allocated by agreement of everybody concerned to Newfoundland. So that was an agreement. What the judge found at page 130, in paragraph 235, was that Mr. Hughes forgot about this or overlooked it. It's the fourth line, 235 on page 130.
So there he's referring to 152 to 157.
Yes.
That's a different stage.
Yes, that's the
Story.
that's partly to do with the profit margin.
Is this the stage at which it's agreed that the partnership will get 1 penny?
Yes, well, Mr. Hughes proposed that the partnership should get 1 penny.
Yeah.
And that was to stop Newfoundland from ordering direct from Acon. And again, just to give you the references before we break, 131, paragraphs 131, 132, 150 and 152.
Sorry, paragraphs 131, 132.
131, 132, 150 and 152, page references of 112 and 115.
Yeah. And as you imply, that's probably a convenient moment.
It would be, Madam, thank you.